I know he pled guilty, but I can't actually look past all the inconsistencies in this case.
The fact that a defendant waives the right to appeal doesn't mean they don't have the right to appeal.
We're not a tunnel channel. We're a legal analysis channel. In the Bryan Kohberger case, the gag order, the non-dissemination order is no more. Documents are going to trickle out. We're not sure when. And you know what? Mr. Kohberger signed away all of his rights to appeal. But did he? Andrew Myers here with another edition of About the Law. Today, we're focusing on the fact that the gag order, the non-dissemination order that has been plaguing the case for 2.5 years now, since Mr. Kohberger was first found in Pennsylvania, it's been lifted suddenly in a hearing in mid-July of 2025, right after Mr. Kohberger pled guilty. But what does it mean? The judge immediately said, well, it does not mean that all the documents that have been sealed throughout the case are automatically made public. They will be at some point made public, but the schedule and the timing is still up in the air, and he will take a look at them one by one going backwards. So that was an interesting revelation. We have our usual About the Law comments. And we also have a question about how final is it really that Mr. Kohberger signed away all of his rights to appeal? People will tell me, I know, down in the comments, I read them. I know people will tell me he signed away his rights to appeal. Really? Let's take a look at what Judge Hippler really said about all of that in a hearing that was held kind of sandwiched in between the change of plea hearing and then the sentencing hearing. In between, he had a hearing, and here it is.
The briefs that have been provided by the parties, and I'm going to...
So he spared us all the arguments. The parties, the media representative, the defense attorneys, Ann Taylor, and the prosecutor, William Thompson, and Ashley Jennings. You see her there in the center and the bottom. He said, I read everything. Going to spare everybody the arguments. Let's go.
Attempt to shortcut things here a little bit by asking whether the defense, who is the objecting party, has anything additional to add beyond what.
We did a close-up there so you can see there's Mr. Kohberger. He's not in the suit and tie or just the dress shirt and tie that he has been wearing at all of these public hearings, but he's not in a prison jumpsuit either. He's in a looks like a sweater, and it looks like it's maroon. I don't know, but we just wanted to give you that quick close-up.
But it had in its briefing before. I don't know that I need to hear from, frankly, the petitioner. I think the briefing was adequate, so let me just start with Ms. Taylor to see if there's anything else she wants to add.
Your Honor, there is not, but if there's further argument, Ms. Barlow will be making that argument on behalf of the defense.
All right.
Obviously, this hearing was not held in the courtroom. The parties who come from all kinds of different locations were allowed to appear by Zoom. I don't want to say this. Looks like Hollywood Squares, doesn't it?
And to be fair, Ms. Olson, was there anything you felt was important to add that was not contained within your briefing?
Your Honor, we would just briefly say in response to the defendant's brief, we certainly understand the expressed concern about the media coverage of their client. We don't think continuing the non-dissemination order helps that at all. It simply continues to limit the ability of the members of the press to reach out to the people who know the most about the case. It doesn't obligate them to say anything. We also understand that they expressed that there was a due process right related to the sentencing. I read the case that they submitted. I think that there is obviously a due process right at sentencing, but I don't think that case is really on.
What due
doesn't provide any
what due process is, and it applies to pretty much every case, civil and criminal, more in the criminal context. And in this case in particular, due process requires notice and an opportunity to be heard. And what the judge is saying is, lifting the non-dissemination order isn't really going to affect that.
Here, because that was about information provided to the court, and given the very limited scope, and we understand it's very important, but given the very limited scope of what's to be decided at the sentencing, we don't think the arguments that Mr. Kohberger made should outweigh at this stage the First Amendment rights of our clients. Thank you, Your Honor.
Thank you. All right, in light of that response by the media outlets or interested outlets, Ms. Barlow, do you want to add anything?
I would only say, Your Honor, as this court is well aware, the publicity in this case is so extensive and emotions are already so high that adding fuel to the fire of media interviews or a rush to interview people as they leave the courthouse or enter the courthouse would only increase the concerns that the defense has. And even though the plea has a specific sentence attached to it, as this court is well aware, things happen in plea hearings and, sentencing hearings. And to minimize the possibility of that, we request that this order stay in place.
All right, thank you. All right, as the court has considered the petition, frankly, the court was prepared at the time the plea was entered to lift the non-dissemination order in order to give the parties time to evaluate that and to ensure I wasn't missing anything. When both sides objected, I agreed to continue the non-dissemination order. I also indicated that I would have the potential to look at that again before sentencing because, frankly, I anticipated the motion from somebody, in this case, the Ms. Olson and her clients, was likely to be coming. And at this point, I do not believe the purpose of the non-dissemination order, the primary purpose, which is to ensure that we can seat a impartial jury, is any longer at play.
In the United States Supreme Court case of Nebraska Press Association, the United States Supreme Court looked at this issue and said that the public has a right to know and it has to be weighed against the defendant's Sixth Amendment right to a fair trial. And part of that, a key important part of that, is that the jury pool not be tainted by incredible publicity that can slant the jury pool. However, now that there's not going to be a trial, now that Mr. Kohberger has entered a plea, that concern is obviated. And so that's why the judge, in my belief, has taken a lot of criticism for continuing the non-dissemination or gag order and continuing the practice of sealing almost everything that's filed, if not everything that's filed. And he's been under a lot of pressure. I don't think, as he's pointed out before, he really, bends to pressure, but he is saying that that Supreme Court weighing balance of First Amendment, Sixth Amendment, that now weighs more towards the First Amendment than the Sixth Amendment. And so that's why he seems to be saying, yep, let's do it.
The concerns identified by the defendant, while certainly not to minimize those, they are concerns and they are significant concerns. I do not think, however, the non-dissemination order and the right of the public to information is outweighed or outweighs those rights, I should say. And frankly, I don't think that lifting the non-dissemination order will meaningfully impact those concerns. I mean, the media frenzy, as it has been described, will continue regardless. It is a little bit like a, water will find low ground in this.
That is a real dig at the media. I mean, it's clear that the people in Idaho aren't very happy about the media that's there. Water seeks its own level. That's a disparaging comment. People in Idaho really don't like cameras. There was a quote in one of the books. The book was While Idaho Slept by J. Reuben Appelman. It came out early in this case. Here's a direct quote from that book. TV crews had entered the building, talking about the courthouse. TV crews had entered the building with tripods over their shoulders like pickaxes in the gold rush for coverage. Hairdos filled the audience. Hairdos, okay, sure. So we know that the people in Idaho, generally speaking, especially the people associated with the courts and law enforcement, aren't really thrilled about the media, are they?
Case, the media is going to write about something regardless.
Yeah, in a big case like this, they sure are. I mean, I don't have my edition of People magazine in front of me, but it's got a splash cover article and many, many, many other people. They're curious, Your Honor, in all due respect. They're curious about a case in which 4 young college kids are done away with in the middle of the night. And yeah, people want to know what happened. I'm sorry. No, I'm not sorry. I apologize.
About this case, the lifting the non-dissemination order does not require the counsel or others who were previously bound by it to speak. And the state has indicated they don't intend to until after the sentencing. And certainly I would hope that the media interests would respect those positions and give people the space that they need and request. In terms of, for example, the defendant's family and others coming and going at the sentencing, we intend to have, as we did before, appropriate security measures in place to ensure that they, as well as the victims, are allowed to get in and out unscathed by the media if that's what they wish to do, or if they wish to speak to the media, they can do that as well. At this point, I just don't think that I can justify the continuation of the non-dissemination order. I think the rights of the public to information in this case is paramount.
It's true that in any big trial like this, and you know, I've been practicing law for over 30 years in Massachusetts and New Hampshire, and it's true that when there's a big case like this, you know, the satellite trucks are out there, the live trucks are out there, and the reporters are there, and you know, they want to get interviews, they want to talk to people. But whether the non-dissemination order really controls the crowd outside the courthouse is difficult, because you know, a lot of these people, you know, they'll do inside interviews. I mean, we have StreamYard. The networks have their satellite trucks. And Steve Goncalves and his wife and their attorney, Shannon Gray, appeared on the Today Show and CBS and other places. I was only able to catch up with a couple of them. And that's all done inside. So that's really not going to control the, you know, you want to call it the scuffle or the crowd outside the courthouse. And in his own kind of way, I think the judge is kind of addressing that. And of course, as he says, no one has an obligation when the TV reporters or radio reporters or any other reporters come over to a party and say, I want to talk to you. The party has no obligation to talk. They can just say, no, thank you, and keep walking.
Given the fact that a plea has been entered in this case, and so I'm going to lift the non-dissemination order. But I want to point out what that means and what it doesn't mean. So obviously nobody's required to speak to the media, first of all. Second of all, I want to be clear that the court's prior preservation order to the parties is not lifted.
And I haven't seen a lot of other commenters point this out. The non-preservation order is really important. It means that if you have evidence, you know, cell phones, extractions from cell phones, photographs, witness statements, you may have had a recording or a transcript of a statement. All that stuff is under the preservation order, and the attorneys are still under that. That has nothing to do with the non-dissemination order. He's just making that clear.
Continues to stay in place. And so it's important to understand that those obligations still exist. And then the other thing I want to point out is that by lifting the non-dissemination order, that does not convert sealed documents to unsealed documents. Documents previously sealed by the court are still sealed.
That was my first question, and he answered it right here, and he's going to tell us all, you know, how that will be handled. But as people that have followed this case closely know, many, many, many of the documents are sealed. They're under lock and key, and so there's going to be a process. And he kind of loosely, you know, gives a summary of how that'll be handled. It's not really clear 100%, but here it is.
Now, I see the media also filed a petition to be heard to unseal everything. I'm denying that outright, the request to intervene, because I think it's premature at this point. So the court will its intent is to, after sentencing, begin the process of reviewing all the sealed material in this case to determine what should be unsealed and what should not be unsealed. That process will include an opportunity for counsel to register any objections to unsealing documents, specific documents, and request to redact certain sealed documents before they are unsealed, or unseal them in a redacted form. I intend to do that in groupings of documents at a time. As I sit here now, my thought is I'm going to start from newest to oldest because those are the ones that I have the most working knowledge of as to the reason for the sealing of the documents as well.
So he's going to start with the most recent documents. There have been documents. There was a discovery document filed just this week as we are recording this episode. So he's familiar with the stuff that's more recent, and some of it, some of the exhibits to some of the Frank's motions, the motions to seal and to suppress evidence. Those he's familiar with. Now they go back to probably late summer and fall of 2024. So a lot of good stuff in there. I mean, some of this stuff has slowly trickled out. The 911 call, the fact that the girls that were in there, Bethany and Dylan, were texting back and forth and going on social media. Some of that stuff, is still under seal. Some of it has come out, it's true, but some of it's still under seal. So he's going to go backwards. And there was some good evidence attached to some of those motions that is going to be interesting. And who knows how long it'll take them to get into that. The timing of it is coming up in a couple of minutes, and we're going to address that when it comes up.
As well as the content of those documents. And so I think I can get through those more quickly. As we move backward in time, it's going to take further, more extensive review by the court to figure out, to obviously review the content of those documents, listen to those hearings, et cetera, and determine why they were sealed and whether that rationale still is necessary, or that rationale still requires the documents to maintain that sealed status. And so before everybody gets out their pen and paper and sends in public records requests, understand.
I did 2 of those when he first came on the bench in this case back in the fall of 2024. I didn't use pen and paper. No, it's all online as a form. He actually posted in the docket of this case that people that wanted documents could apply. Here's the form. Here's the procedure. Here's who you send it to. And I did all that, and it did not involve a pen and paper. It involved an online process. What he's saying is no, none of the stuff that's sealed is going to be released until and unless I say it is. So anyhow, I did try. I'll try again.
And those will be denied for sealed records until
they
are unsealed. And that process is going to take time. And I'm not talking days. I'm probably not talking weeks for that to be accomplished. So I hope people understand patience will be required to get through that, as I'm going to have to review those myself to make those decisions. Now, we may be able to speed things up if neither party objects to groupings of documents or specific documents being unsealed. But it's important to review those because those documents may include information that, pursuant to Rule 32, are not to be made public, including birth dates, social securities, information about minors and victims, and information that would be inappropriate to.
That is a real no-no in, all the courts, especially the federal courts. The PII, personal identifying information, there's a real prohibition on releasing that type of information, social security numbers, dates of birth, full names, addresses. That's the kind of information that can be very much misused. So that has to be redacted. In fact, there are penalties for attorneys that do disclose that information. So also, identities of minors. Minors are very much protected. So as you just said, that should be easy though. I would think would be a clerical task for, law students and law clerks, and that kind of stuff should be able to help with that, I would think. But more questions.
Unseal, including protection of individuals from undue harassment, et cetera. And so that's just going to take time. In addition, I'm unlikely to unseal much until after sentencing and after the appeals period has run. Now,
wait a minute. Until after the appeals period is run, didn't we all just hear the other day or a week before that Mr. Kohberger had waived all right to appeal? Let's hear that again.
I recognize the plea agreement includes a waiver of the right to appeal, but as the parties probably know, the U.S. Supreme Court in Garza versus Idaho has indicated the fact that a defendant waives the right to appeal doesn't mean they don't have the right to appeal.
Wait
so
a
it
minute.
may
Now, this
affect-
was kind of new to a lot of us. I don't practice law in Idaho. I'm licensed and have been for several decades in Massachusetts and New Hampshire. So I know I'm going to get comments down below. Well, he waived his right to appeal. Well, he waived his right to appeal. Did he really? Let's take a look at the law. The United States Supreme Court kind of told Idaho, not so fast. Here's the case. I briefed it. I know some other people have read summaries of the case, but I read the case, and actually some of the information that I briefed and found in the case of Gilberto Garza versus Idaho, I found down in the footnotes. I always tell my viewers, read the footnotes, because a lot of information is down in there. Gilberto Garza Jr. signed 2 plea agreements, each arising from state criminal charges, and each contained a clause stating that Garza waived his right to appeal. Does that sound familiar? Garza later filed an affidavit saying that he was persuaded to plead guilty by the prosecuting attorney and his counsel, which was not voluntary. Now, you can check the case. There's the citation, Garza versus Idaho, United States Supreme Court, citation 139, Supreme Court 738. It was decided February 27th, 2019. So even though he signed a waiver, he wanted to appeal. And the issue was whether the signing of an appeal waiver, in fact, served as a bar to all possible appellate claims. In the body of this decision, United States Supreme Court decision, the rule of law was no appeal waiver serves as an absolute bar to all appellate claims. Some claims are treated as unwaivable. Most fundamentally, courts agree that defendants retain the right to challenge whether the waiver itself was knowing and voluntary. Then the analysis that the court went into. Now, this is a 35-page United States Supreme Court decision. So I'm not going to tell you all about the 35 pages. It all boiled down to this. The term appeal waivers can misleadingly suggest a monolithic end to all appellate rights. In fact, no appeal waiver served as an absolute bar to all appellate claims. Did everybody in the audience see the movie 2001 where you hear that really dramatic music? Then you see this huge monolith. That's what comes to mind when I read this, that the United States Supreme Court said the term appeal waivers can misleadingly suggest a monolithic end to all appellate rights, because it doesn't. And the other language I found in the 35 pages of analysis was that a defendant who has signed an appeal waiver does not necessarily, quote, undertake a chaotic or frivolous request. So this isn't frivolous. This isn't to be brushed under the carpet. This isn't a minor thing, the court was saying. At least consider it. may not have a chance, but the court's saying, hey, Idaho, at least consider it. So the final holding was that the court held that even the broadest appeal waiver does not deprive a defendant of all appellate claims. Interesting. The case was remanded back to the Idaho courts for further proceedings, not inconsistent with this opinion. What remand means is it just goes back down to the courts in Idaho. And interestingly, the decision was written by Justice Sotomayor, and she was joined by 5 other justices. So the vote in the United States Supreme Court on this issue was 6-3. Supreme Court followers are want to understand that many decisions of late generally tend to be 5-4. They're nail biters, 5-4, 4-5, 5-4. This one was 6-3. So the court was somewhat certain, at least on this issue. So let's go back to Judge Hippler.
As indicated, the fact that a defendant waives the right to appeal doesn't mean they don't have the right to appeal. And so it may affect the outcome of that appeal, and it may affect the underlying case and the plea agreement. But nonetheless, the right to appeal does not go away because of the waiver. And so I think it's important for that time period to also play itself out.
Comment down below. You thought that the right to appeal was all written off? Not so fast.
To see that it goes the way that I think people intend and expect it to. And so I will be entering an order in the next week or so outlining the process for the review of the sealed records. And counsel will need to maintain a presence in the case in order to review those materials as they are proposed to be unsealed by the court. Because the timeline that I will likely give you will not be, I suspect, extensive as for each group of records. So I might give you 14 days, for example, to provide a response as to a group of, a dozen or a couple dozen records at a time. So just sort of heads up and fair play with respect to that. Any questions by the parties about the ruling today?
I couldn't believe this. They're all sheep. I mean, they're all silent. No questions. Now, my questions would be, tell me more about this procedure. You say that you're going to be taking a look at these in batches. How are those batches going to be, selected? Now, as prosecutor or as defense attorney, do you want us to brief the issues in advance to save you time and give you some red line indications as to what we think can and can't be revealed? Do you want us to make it easier for you by giving you some motions to allow or disallow certain documents? I mean, the attorneys either wrote all of these documents or read opposing counsel's documents. So it would seem to me, I have a lot of questions. When do we start with this process? When you tell us that you have a batch of documents you're looking at, will you issue a decision and give us X amount of time? How much time? Will we be conferencing these things? In other words, if the prosecution wants something to remain silent and secret and the defense doesn't, what's the process? Will it be briefed? Will it be argued? Will it just be on the papers? What do you expect from us? I mean, I had so many questions. So I was shocked that there were no questions. I was shocked that there was just, video silence on this.
Not from the state, Your Honor. Thank you.
No questions from the defense. Thank you.
Shocking. I found that shocking.
Wilson, do you have any questions?
And I don't, Your Honor. I wasn't certain if I was included within the parties. I would just say I think that the court's proposed manner of moving forward on the sealed records will likely largely address our interests, and we appreciate the court setting that out in this hearing today.
Yeah. If certain records after review maintain their sealed status, it would be at that point that I would entertain requests for me to.
See, even the judge, anticipated some questions and he got none. So he's, giving them a little bit of an idea of what they can expect. I mean, I would have had a couple of questions. When a judge tells you in open court, if you have a question, you take that opportunity to speak and you put it in the form of the question, and that's easy. So I don't know. I was shocked.
To consider that more formally and to have a voice in that. But I think until I've gone through that process, it's premature, which is why I don't intend to take up your motion, your more recent filed motion at this time. So,
Thank you, Your Honor. We appreciate that.
all right. And with that, then we are adjourned. Thank you.
Okay, so that's the hearing itself. It really was very brief. It was about 12, 13 minutes, depending on what you counted. You know, we edited out the very beginning where the judge introduced all the parties and stated who was there, who was in all of those boxes, the defense attorneys, the prosecuting attorneys, like I said before, Ashley Jennings and William Thompson, the attorney Olson for the press. So he identified all the parties. He read the case name and all that good stuff. So we cut that out just in the interest of brevity. And so I think the whole thing was about 12 minutes, and that was that. So now the process will begin. Now the non-dissemination order is lifted. Now all of the parties who were barred from speaking out may speak out. And again, like I mentioned earlier in this episode, Mr. Goncalves and his wife and their attorney, Shannon Gray, was on Good Morning America. Was on the Today Show, the CBS Morning Show. I can't remember this. So you will see more. I was shocked when this happened so quickly. And I went on with another creator, our friend Evil CJ. I was on live with him the day that this happened because I was kind of shocked. And we talked about, you know, what's to happen next. And we're all just a little bit shocked by how fast this came down. He and I made a bet. He doesn't think anything exciting is going to come out. He doesn't think I hate the word bombshells, as you know, but he doesn't think anything, you know, huge and significant like that will come out. I bet him a cup of coffee. I think there is stuff that's in these sealed documents that's really going to blow us all away. That's really going to, you know, change things. There has to be something. I mean, why did Ann Taylor file so many motions, 20, 21, 23 motions to suppress evidence? About the same number of motions to take the DP off the table. There were tons of other motions all the way through. And she fought all the way through, and she said she wasn't ready because there were 68 terabytes and she hadn't gotten through all the documents in 1 week. Then the next week she answered the question, yes, she's done all the discovery. So there are just so many questions, and I just have so many questions. I am not a pro-burger, as I have been accused of doing, but it's important for all of us to keep our minds on. We're not going down in the tunnels. We're not going out on the Banfield or anything like that. I just like to be analytical in a channel like this, a legal channel where, you know, it's up to us to analyze what's happening and think it through. So I was surprised at the results of a poll we did. We did a poll and the questions were guilty, not guilty, guilty, but we still have questions, not guilty, because there are so many questions. And then there was another category. So without any further ado, so here's the poll. Here are the results of our poll. And again, I was surprised of the many people that responded to our poll that we put out now a week ago. 9% said they believe Mr. Kohberger is guilty. 7% said they think he's not guilty after all of this. 21% said he's guilty, but there are many unanswered questions. 58%, the largest number of people who responded to our poll, said he was not guilty. Something is fishy here. So that's the majority. And then other, I put together this poll and it was 1, 2, 3, 4. But then all of a sudden I said, I have a hard time with this. As an attorney, as I said before, so I won't take too much time, I have to respect what happened in the court. I have to understand that the colloquy was made and Mr. Kohberger answered that, yes, he's saying that he's guilty because he was guilty. He was answering the questions freely and voluntarily. He wasn't under the influence of any of the parties, and he wasn't under the influence of any substances, legal or otherwise, that would cloud his thinking. So as an attorney, I have to kind of accept what the court's done, but there are so many questions. I said, I don't know where I stand on my own poll. So I kind of tainted the thing by having a fifth category, other, and about 5% of you agreed with me that it's other. Now, if you some people gave us 2 numbers. Well, it's either 2 or 3. We didn't count those. If you're on the fence, on election day, when you go to the poll, that's not an option. You have to vote for candidate A or candidate B. You got to go with blue or red, whether you like it or not. There is an option for being an independent, which I am, and I have been my whole life. I don't do politics on this channel. But so if you answered that you were either a 1 or a 3 or a 2 or a 4, or you didn't know, or if you wrote down guilty but didn't put the number, that wasn't counted because we did this numerically. But there are the results. Guilty 9%, not guilty 7%, guilty but many unanswered questions 21%, and the largest category. And this is what surprised me, where we're not a tunnel channel, we're a legal analysis channel, and I would like to think that our audience, skews towards wanting analysis and facts and law, but our audience says not guilty. Something's fishy. And then the final category was other. So that's it. And here are some of the comments that we got. We released preliminary results in a previous episode. These are the final results. The poll's over, folks. I've done enough counting over the last week. But here are some of the comments that we got. Mariana 8972 said, wow, to the poll results. I know that I feel strongly something is very wrong with this case, but I wasn't sure how many still thought that after the guilty plea, time to get documents released and investigate the investigators. Well, the documents are going to be released one by one, and it remains to be seen, how much will still remain redacted. Remains to be seen. I'm not certain the investigators will ever be investigated, unfortunately, despite what Mariana says. The victims deserve better, and quite obviously, so does Kohberger. I strike the last part. I think the victims do deserve better. What the message of the Goncalveses was when they spoke on the Today Show on NBC was, yes, they have met with the law enforcement. They were extremely upset that this came down so quickly without any input from them. But at this point, at least what they said outwardly on the networks was that they have met with law enforcement, and law enforcement has assured them that they will, remain in touch with them about, what's in the documents and what was done in the investigation that they didn't know about before. Comment number 4. Kylie at Ivy. I know he pled guilty, but I can't actually look past all the inconsistencies in this case to get my mind around the fact that he actually did it. I'm hoping we get to see more info about Dylan and Bethany, but sadly, I think this will remain sealed. Probably. I don't know. I can't answer that. I would imagine that I would think that the 2 happiest people on the planet right now this week are Dylan and Bethany, because, they're not going to be called to testify. Dylan, I've said things about Dylan, as an attorney, that she would be cross-examined quite with a lot of scrutiny, and people have excoriated me down below. Well, she's just a young person. She is just a young person, but she did live through what she did, and what happened that night is what happened that night. I'm not sure we'll ever find out what happened in that 8 hours. And that's the biggest mystery to me. What happened in that 8 hours between, if you accept law enforcement's timeline, that the crimes occurred right after 4 o'clock on November 13th of 2022. And then the 911 call, which wasn't made until 11:58. So that's a huge mystery. And I think we'll all have questions forever and ever and ever until those questions are answered. And I don't think they'll ever be answered to my satisfaction. Number 3, Caroline Prestige. I need a detailed confession from Kohberger before I believe he did it. This case has so many unanswered questions. Well, the first thing, in Caroline Prestige, are you in relation to the great journalist that I worked with many years ago? There was a journalist in New Hampshire by the name of John Prestige, and I worked with him. And I wonder if you're in a relation. It's not that common of a name, but anyhow, that's not how it works. Unfortunately, it doesn't work that there's a detailed confession. All they had to do was show sufficient facts to back up the guilty plea that there was something to it, and there didn't need to be a detailed confession. The sad thing is, to my mind anyhow, these details could come out in dribs and drabs over the years if Mr. Kohberger is allowed to, do various interviews. And we all know that his professor back in Pennsylvania has said that she does, in fact, want to interview him. Catherine Ramsland, of course, was the professor that taught him in Pennsylvania. And she also, did extensive interviews with Dennis Rader, the BTK criminal. And she's stated her intent that she, does want to go and talk to Mr. Kohberger. So that's the kind of thing that likely will come out in dribs and drabs. And so, Caroline, it's unfortunate that the legal process is not going to address that concern. And it's also unfortunate that, Mr. Kohberger likely will be in control of what comes out. Do any of us believe him or anything he says? Number 2, Life Seeker. The roommate issue is weird, but honestly, Kohberger is a seemingly odd loner. I just don't think he would collaborate with someone else. I think he is guilty, and guilty as a single perpetrator. Okay. All right. I've said all along, and we even did an episode some time ago with another collaborator in which we said, I forget how many reasons we had. We had a dozen reasons, 18 reasons why this was done by 2 perpetrators. But I think this commenter, Life Seeker, makes a good point. Kohberger is a seemingly odd loner, and it is kind of hard to understand that he would collaborate with someone else, but the evidence shows that it's awful darn difficult to believe that he did. Our number 1 commenter this week is Catherine Pawson. When Judge Hippler was asking Bryan Kohberger for his guilty plea, the answer came across cold and deliberate. I agree. Way too deliberate. I don't know. I don't know. I've never been in those shoes, so I don't know how one would behave in those shoes. Although sociopaths are known for their unemotional response, there is doubt and will always be, given the unanswered questions. I vote not guilty unless it's proven not to be true. Other factions could be at play here. The girls just got in over their heads. Kaylee may have borne the brunt of injury given the role she played in the events. I just don't know. There are so many unanswered questions. The interesting thing here that I'm not a psychologist. I listened to a really good review by a counselor who does another YouTube channel, who did listen to everything in this case and read everything in the case, and did a really good episode of his own talking about Mr. Kohberger, and pointed out, as we all know from listening and reading earlier in this case, that Mr. Kohberger himself said early in his life, in his teenage years, that he didn't feel emotion and he felt disassociated with life. And so it's not surprising that he was so emotionless. I just don't know. I really don't. And finally, we always have to remind everybody that this case is about the Idaho 4. Their parents will never forget them. Their friends will never forget them. I don't think the people at the University of Idaho will ever forget them. Xana Kernodle, Ethan Chapin, Madison Mogen, and of course, Kaylee Goncalves, all 4. They are the Idaho 4. And it's just, this is something that will be with them and with us and with everyone for a long time. And so I would like to ask you all that if you've gotten something out of this episode, that you would please subscribe, like, and share. We are now up to 75 countries have had commenters that have either commented or asked questions, and of course, all 50 states. And so we would ask you to please subscribe, share. If you have listened all the way to the end of this episode, I would ask you to place an emoji of, this week, let's ask you to put a sunshine. Because, sunshine and opening the windows are the best truth finder ever. So thank you. Hope to see you in the next episode. Have a good one. Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one. I know he pled guilty, but I can't actually look past all the inconsistencies in this case.
The fact that a defendant waives the right to appeal doesn't mean they don't have the right to appeal.
We're not a tunnel channel. We're a legal analysis channel.